We are back on the record. I'm JU 8801. All parties are present with counsel, as well as foster parents are present, and we now have resolved at least, I believe, in whatever little technical issues we were all experiencing, those of us that are using the internet to access Alicourt. So, with that, we're down to the motion to suppress testimony and records in limine.
Yes, ma'am.
That's it, right?
Yes, ma'am.
Okay, Mr. Kirby, go ahead.
And the reason I filed a motion to suppress because I couldn't find the limine motion. But
Oh, and when you're talking about when you did the drop-down box.
when you do the drop-down box in Alicourt, yes, ma'am.
Okay.
The way we're moving to suppress records. I think we've already dealt with paragraphs 1 through 6,
Okay.
or 1 through 7. I'd just like to.
Let me check.
Okay.
Okay. So, we're through 1 through 7.
Well, actually, I just want to bring back to the court's attention that even if the records from DHR were produced today, it makes it hard to present a fully viable defense for the Holms in this matter. And even though the records were produced today, we'll move on. One of the issues that we had last week was the father's counseling records from Savannah Counseling. We're stating that we're contending that all those should be deemed inadmissible due to several rules. Rule 503, which is of the Alabama Rules of Evidence, which is psychotherapist patient privilege. I go through the definitions of what a patient, what a psychotherapist is, and communications is confidential if not intended to be disclosed to third persons other than those present to further the interest of the patient in the consultation, examination, or interview. As a general rule, the patient has the right to refuse to disclose and to prevent any other person from disclosing confidential information about themselves, and that privilege can be claimed by the patient. And I think that, of course, without talking to the medical doctors that were associated with those records, I think you have to assume that the patient claimed that privilege. He would not want that information released. There are some exceptions, of course, to 503, and that's proceedings for hospitalization. Of course, we believe that none of those records, even though we just had an opportunity to view them for a short time on December the 5th, we don't believe that any of those records were for hospitalization efforts. Another exception is examination by order of the court. This court has not ordered Mr. Holm to be psychologically examined, so therefore it doesn't meet that exception. Accused in a criminal case, not a criminal case, this is a dependency case, and a breach of duty arising out of a psychotherapist-patient relationship. Of course, that's not what this case is about. And then number 5, it says child custody cases. In a sense, this is not a child custody case, this is a child dependency case. The state's arguing that the child doesn't have a parent or legal guardian that's willing or able to take care of that child. So I don't know that it meets the definition of the child custody case in the traditional sense, as one party against another, say in a divorce. There's no exceptions to the rule that would allow the admission of any counseling records of the father. I guess one question that would probably arise is how the state got those records. If they claim to have gotten those records under a release of information, then that release of information should have been HIPAA compliant. Of course, without being able to review the records that the DHR did not produce to us, we weren't able to see what that release of information was until today. Glancing at it, I don't believe the release is HIPAA compliant. I don't believe that it has on there that this release is good from this date to this date, and I believe that has to be on a HIPAA release and who the information can be released to. And I know, our standard HIPAA release, which is HIPAA compliant, has a lot more information on it than, hey, we're requesting these records. And we're claiming that the father's counseling records are inadmissible pursuant to Rule 503A, which is counselor-client privilege, for which there's no exception applicable, and asking that all of those, the counseling records be deemed admissible. Point out to the court that a communication is confidential if it's not intended to be disclosed to third persons other than those to whom disclosure is made in furtherance of the rendition of professional and counseling service to the client, or to those whom disclosure is reasonably necessary for the transmission of communication. If we could get the counseling records of everybody that we thought believed differently than us, then there would be an issue. If we could just willy-nilly get those, request them, it would discourage people from going into counseling if they knew that their records would just be admissible or accessible to everybody. And I've laid out a couple of definitions there. There are some exceptions to the rule. But the counseling records sought to be entered by the state don't meet any of those exceptions. One of the exceptions is counseling, or to assist a person through a counseling relationship to develop an understanding of personal problems. Well, Mr. Holm's not subject to those. Appraisal activities, counseling, guidance, and personal consulting, referral activities, research activities, victim counseling. Now, the records sought to be introduced by the state don't meet any of those exceptions. And then once again, the privilege is claimed by the client for 503 or 503A as well as 503. I'm sorry, the exceptions, were examination by order of the court, of course, which has not been ordered. The client's condition is an element of a claim or a defense. That's not part of the defense in this action. Breach of a duty arising out of client-counselor relationship. Of course, this is not a suit against any counselors, and victims counseling in civil cases. Further, the parents or the attorneys of record at that time believed that the state or the department will offer testimony from Mrs. Edith Couch or some licensed counselor to testify as to the records that they subpoenaed or they got under request. Anyway, the father's counseling records. It's believed that Ms. Couch's testimony will be offered to provide expert testimony as to the father's counseling records. The the parents or the attorneys, Mr. and Miss Holm, have never seen Edith Couch, and as such, she could not have any personal knowledge of the parents or the matter at bar. If Ms. Couch does have personal knowledge or does have knowledge of any records supplied to her by the department, we're claiming that that would be in violation of HIPAA, as well as the psychotherapist patient privilege and counselor client privilege. Ms. Couch's testimony should be deemed inadmissible, not allowed on those grounds alone. And I threw in there, I think if the state was going to call Ms. Couch, they should have notified the other parties prior to the day of court, or any expert, any person that they're going to try to qualify as an expert to testify to any counseling records. That brings us to Rule 702, testimony by experts or witnesses. Of course, it's not uncommon to have testimony by experts and witnesses or experts, but that testimony has to be based on sufficient facts or data. Since Mrs. Couch or no other counselor has met with the Holms, we contend that they wouldn't have sufficient facts or data in front of them to make any kind of judgment as to the records provided by Savannah Counseling. Probably one that, or someone that could testify as to those records would be the treating physician, and it's cited in Armstead versus Smith and Jones v. Keith. If the state wants to try to introduce testimony of records that might involve prescriptions, those records were obviously created by a doctor and not a psychologist. As we all know, psychologists can't prescribe medicine. Probably the best evidence would be to have one of the treating physicians that was associated with those records come testify as to anything that are on those records. I understand it's out of state, but the state's had plenty of time to issue an out-of-state subpoena to get somebody here. That doesn't guarantee, of course, I know that doesn't guarantee that they will be here, but that could have been done. This has been going on since October the 11th, I think. One thing I'd like to remind the court, Rule 703 leaves unaffected the pre-existing law requiring the facts or data relied upon by the expert and gotten by the expert other than first-hand knowledge generally must be admitted into evidence. We don't believe those records are admissible into evidence based on the opinion, hearsay, and best evidence and expert testimony rules. This came from McElroy's evidence, 130.01. It says, however, it should be emphasized that Alabama case law generally precluding an opinion based on the unadmitted records or reports does recognize, or reports of others does recognize exceptions. We don't think that Edith Couch can be qualified, or any local counselor can be qualified as an expert to testify on these records. Once again, Mrs. Couch or any other licensed counselor, unless they could testify as a medical doctor, would be able to give any expert testimony as to somebody who was a doctor that made any diagnosis or wrote any prescriptions for those records. Yeah, and when we were here on December the 5th, the department attempted to introduce the father's counseling records. In Gamble's Alabama Rules of Evidence 8036, it should be emphasized that satisfying the hearsay exception does not give the evidence carte blanche admissibility over independent objections such as those relating to opinion, irrelevancy, best evidence, etc. So even if the court found that Ms. Couch could be qualified as an expert, we've still got to address the issues of best evidence. Well, we got to satisfy all the issues: the 503, the 503A, the best evidence, which is 1002, I believe. 802, which is hearsay. That's what we're going to next, is the hearsay rule. Of course, hearsay is not admissible except as provided by these rules or by the rules adopted by the court. Of course, we know that there is a business record exception to the hearsay rule, but who's to testify? The records in question, the father's counseling records, who excuse me, who is to testify, or who can Mr. and Mrs. Holm even cross that could testify as that these are actual records kept in the ordinary course of business in that particular institution or doctor's office or whatever it is. There's nobody here to say that. And I think you have to have that to get by the exception to the hearsay rule. Especially, excuse me, especially from somebody that's out of state. To prove the content of a writing, we'll go back to the best evidence rule, and to prove the content of a writing, the original writing is required. Of course, I know the state wouldn't have access to the original. I'm not blind to that fact, but the thing is, they could have received copies that weren't faxed over. Because nobody knows who's on the end of that line and what they're, who they are in that company. I would think something from the custodian of records addressed to the state would be more compliant than something that was just faxed over from somebody who claims to be, but you don't know who they really are. I don't know if that's a counselor doing that, or is it a counselor that was involved in any of the records that sought to be admitted. And that's something we'll never know. Also, the admission of any counseling records of the father would so prejudice the father in that neither of the parents or the attorneys have had a chance to thoroughly inspect the record so as to provide their own expert testimony in rebuttal, if the court allows expert testimony to be given. And then we move on to Rule 403, which is relevancy. exclusion of relevant evidence on ground of prejudice, confusion, or waste of time, although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury, or considerations of undue delay, waste of time, and needless presentation of cumulative evidence. Once again, we believe that it would prejudice the father so greatly not to be able to provide any rebuttal testimony by his own expert. These records were part of the records of DHR that were not given to us, although you are correct. I guess they could have been sought by subpoena. But as such, the parents are indigent and probably couldn't have afforded to pay for those records even if they could have subpoenaed them, because I'm sure there's a charge to get those records. There certainly is at the Regional Medical Center. That to admit any evidence made by a declarant who is unable to testify would be a violation of the parent's Sixth Amendment constitutional right to confront witnesses against them. Of course, I understand the court probably knows what the Sixth Amendment is, but it definitely says to be confronted with the witnesses against him. If those records are allowed to be admitted, there is no witness that would be testifying as to those records, except for possibly a counselor who has no knowledge of Mr. and Ms. Holm. So, how can Mr. and Mrs. Holm possibly defend against that? She's certainly not a witness to this case. I don't know how she was provided facts or information.
She being
Ms. Couch, or any counselor, I guess. I'm sorry. How they would have gotten information, what kind of knowledge they have, and so I think this should be excluded as per the Sixth Amendment right to confrontation, as well as Alabama's Article 1, Section 6 confrontation clause. So what we're doing is we're asking the court to deem these records, deem the counseling records and any records, or counseling records and any testimony concerning the counseling records, also any records that DHR failed to provide until today, or testimony about, or that had anything to do concerning those records, deem those inadmissible, and direct DHR that or the state that they couldn't question any witnesses about that, couldn't call any witnesses if they were going to testify as to something that was either in the medical records or the records not provided. That will be our motion, Your Honor.
Your Honor, there's a lot there.
There is, and this was one that was filed after 5 o'clock last night. So I am assuming you are okay going forward with this because it sort of hinged on some other, your motion to alter, amend and stuff?
Your Honor, I'm okay going forward with it because I on my very, very brief review of it this morning, I assume these would be the same objections we'd be dealing with in the middle of trial anyways.
Okay.
So it's not as shocking as the other one.
So, bottom line, state waives any due process issue as to this
yes,
motion in limine.
Yes, I think it'll speed up the trial one way or the other.
Okay.
Your Honor, let me start with the records. So, 503 talks about an exception for a child custody case. It's funny, actually, in reviewing the other motion, 33B209 talks about child custody cases, and you got to file an affidavit in all child custody cases. And you got to do that in a dependency case because it's a child custody case. This is, at its very nature, a child custody case. The purpose is determining where is the child going to be placed. There is nothing other than to call it a child custody case. It may have a dependency spin on or whatever, but again, it is child custody, so 503 is absolutely satisfied. These records are admissible, or are well, that is satisfied. These records are admissible as a business record because under 902, they are a certified domestic record. There is now the department has now received a certification from the council or from Savannah Counseling Services that these are in fact the records, the whole records. This is submitted by Joyce and Panasha, the medical record clerk at Savannah Counseling Services, 800 East 70th Street, Savannah, Georgia 31405.
And let me just stop you right there. That was not included in the records we had in camera, correct?
That is the only part of that document that was not included in that.
Okay, go ahead.
And I would proffer that at least that part of the document is for trial purposes, and that is part of attorney work product getting ready for trial.
Okay.
These records themselves have been available to the Holms since probably the day of their creation. They have been, a copy of them has been with the court since last week. The issue of Dad's mental health has already come up, and in fact, if the court will recall, he was asked whether he was diagnosed with schizophrenia, and he asserted his Fifth Amendment. So, again, this issue is already in play, and I would deem that could be construed as a affirmative answer by his refusal to answer such a question. He was also asked whether or not he had suffered from delusional disorder, and again, he also asserted his Fifth Amendment right, which again can be deemed as an answer of that. As to the expert witness, the expert is not going, it obviously has not seen Mr. and Mrs. Holm. What the purpose of Ms. Couch is to provide expert testimony as to what schizophrenia is, what delusional disorder is, appropriate levels of treatment, and other concerns that the department has as a result of statements by Mr. and Mrs. Holm, as well as that has been determined by these records. So her testimony is more than relevant to this proceeding, and certainly I have no doubt that someone will question her credentials when she's provided, but again, I think she certainly meets the appropriate credentials to provide such testimony. She is a LPC. She has the authority to make diagnostic impressions. She provides mental illness counseling to people on a regular basis. That is what she does for her career. And again, that is the manner and she has specialization in that. That is what her expert testimony is deemed to elicit. And I would also say, Judge, that it's obvious that I'll strike that. Finally, Judge, I will just finish with this. I keep hearing the parents bemoan the fact that, well, there was this and there was that, and we weren't provided with this and provided with that. The parents, as their own attorneys, had a duty to investigate and prosecute their case in the way that they wanted to. That included doing subpoenas as they wanted to, whether they would have incurred the cost or not. Again, that is something that every litigant curtails. When they terminated the representation that they had, they undertook that responsibility. It is not a legitimate reason for them to have records denied by the court just because they elected to not do their own due diligence.
Judge, I guess I would echo a lot of the department's arguments, and rather than repeating them, I guess just hit on a couple of things. I do think these records are relevant, and provided that there is proper authentication to admit them into evidence, I think that they should be admitted. The father testified at the shelter care hearing about these documents, about his treatment at this facility, about his diagnosis, and about what he actually received Social Security benefits for. Certainly, I think these documents are relevant to his testimony under oath about that, to either verify that or if there's something different in there, I certainly think that that's relevant and probative.
Judge, I think the state's making quite a presumption when they talk about Mr. Holm taking the fifth on that. I guess they're presuming that you inferred that he had been diagnosed with that. So, Mr. Holm apparently testified at the shelter care hearing about ADD and depression, and that's all that I know that he testified at the shelter care hearing about. Or maybe that's what the disability is based on.
I'm not even sure.
My recollection, and I'm going to take, and I guess at this point, Mr. Kirby, you were not here, but the mom and dad did testify. They were both represented by counsel. It was a rather lengthy testimony. And my recollection of that, and I'm going to take judicial notice of mom and dad's testimony of that portion of the proceedings, because I did hear it, it was bipolar disorder, ADD or ADHD, and depression that had been medicated, and he had stopped medication, but I don't remember at what point in time, because that was I remember asking Mr. Holm, what was your basis of your disability? And it pretty much hinged on the bipolar, the mental health issues coming out of, and I do believe he said Savannah Counseling was where he had been treated.
Objection, I said
And that's-
depression and ADD. I never said bipolar. I've never said bipolar in my life to anybody.
And I guess,
I've never even been diagnosed with that.
That's one reason we asked for the transcripts to see exactly what the testimony was.
I'd be claiming against my own diagnosis.
Judge, I'm going to object. This is exactly what you were talking about, which was double barreling this.
Right.
Mr. Kirby is the one speaking. I would ask that anything that Mr. Holland say be struck, and that
It needs to be directed through Mr. Kirby. He's the one arguing your motion. Okay, Mr. Kirby, I'm sorry, I didn't mean to interrupt you. Got you trying to thought there.
Okay. Right. Okay. Judge, I guess we would have to take exception and
I understand.
say that the bipolar was not admitted to in shelter care, and it was ADHD and depression. But either way, we're moving to exclude those records, and as I mentioned earlier, all records that DHR has not provided to us. And again, I question the method in which those records, the counseling records, were received. So. Well, okay. And I guess one thing to
Yes, sir.
remind the court that the child was taken before the records were gotten. So, what basis did DHR have to take that child based on any kind of non-professional opinion of a caseworker? So.
Judge, the petition itself addresses DHR's concern of mental health. So again, that has been there, and I do take exception with the idea that the worker has some non-professional assessment. Particularly the social worker that was involved in this is a master's level social worker. She certainly has ample qualifications to be concerned about mental health based on her prior experiences in life. And again, that's what she was relying upon as well with regards to her making that determination. And again, this has been at the crux of this case since the very inception, since October 11th when we filed this. that mental health has been an issue.
Anything further from the guardian?
No, Your Honor.
Okay, Mr. Kirby, anything further?
No, miss. Well, I guess I would like, before we end this up, what evidence
Did this mess?
did the caseworker observe to make a determination that should have been done by a psychologist, a licensed psychologist or psychiatrist, that would even lead to taking a child away?
Your Honor, we are not done with evidence yet, and I believe Mr. Kirby or Mr. Holm or Mrs. Holm will have an opportunity to see that witness and ask those questions.
I think you're correct on that issue. You're right, okay. I went back and looked at my notes. Gets SSI for severe depression and ADHD. No by Holm. 2 months on SSI, diagnosed, 8 years taking Wellbutrin and Adderall, discontinued the medications because took himself off, feels that he functions correctly with that medication.
I agree. Thank you, Your Honor.
Sorry it took me so long to find them up here. Okay. And with that being said, as to the department's records that they have provided today in total, again, from what I gleaned in the narrative, which was not a lot of narrative, a large part of that was narrative consisting of interaction with Mr. and Ms. Holm. I'm sorry. So obviously Mr. and Ms. Holm would have been present and engaged in that part for the narrative to have been created. The records as far as the, there were some interesting records that I said, here, these appear to be Facebook postings by your client. I'm not going to read them. Here they are. Those are what they are. However, the department may want to use them. They can use them. If your client generated them, he certainly had knowledge of them. If his contention is he did not generate them, then I'll take that also. I mean, obviously, I believe they unless they recall Mr. Holm. As far as the psychiatric records, Mr. Holm's very aware of whatever his records are, where they were at, signed a release, pulled back that release. I understand why he did that, but nonetheless, those records, if they were indeed received at the time the release was valid, it's something that was there, could have been assessed by your client. He knows what was there. And I guess at this point, we'll tread very carefully. I do think that the probative value at this point outweighs the prejudicial effect. When Ms. Couch testifies, you certainly have the right to raise your issues. And I'm sure it may hinge in part on whether or not that release was still valid at that point. And that does not mean that these records right here that were deemed not admissible, this exhibit number 5 is still not admitted. So I guess the state has to try again if they wished to.
Right. Well, I guess, Judge, I would need to see the state's new certification.
Absolutely.
Well, should we go over this now? You can certainly present that to the judge. Judge, Mr. Holm revoked his authorization on December the 6th, and he did that by way of filing with the court. That certification is for December the 8th. So we're going to still argue that those records are not admissible. Basically what they did is just had somebody send them a sworn statement certification, and they're trying to admit the same medical records that they tried to admit on December the 5th, which let's see. That were faxed over on November the 14th of 2016 at 3:58 in the afternoon. So we're going to ask that, they can't cure that just by getting a certification sent over after the patient's or revoked his authorization.
Your Honor, we can cure it because, again, the records had already been produced. It was, and in fact, on December 2nd, if you look at number 5, the same person said, I sent those records. The court deemed that not to be a sworn statement, and so, or to make them certified, and so she again then submitted the same document, except this time it is now certified. So this is not a new production of records. These are the same records. The way that Savannah produces them is the way that they produce them. They say that they only fax records, and that she was willing to mail this to us. These are the records as they have been produced, and these are the same records that Miss Ampanash swears that are the records in their possession. And again, it is the same person, it is the same documents, it is just now a sworn statement. And again, there is no need for a HIPAA to be in place for that because the production had already been made. Again, it is for the purposes of her certifying that they are authentic. Also, as I recall, I believe the state also sent a trial subpoena to her. Did we not?
Judge, while Mr. Flinker's looking that up, my fast is the records that were not admissible last Monday because not being properly authenticated. The person that signed this affidavit, that's a sworn statement, there's no guarantee that they reviewed these records and that they're records and kept in the ordinary course of business. All they did was send they sent a sworn statement, basically says, well, hey, what I sent you before, I guess, I didn't read the statement fully. I looked at the date. I was more interested in the date.
Why don't you review the statement? While Mr. Slinker's looking for
Judge, let me read it. I, Joyce Ampanash, hereby swear in writing that I am the medical record clerk of Savannah Counseling Services, organized and operated pursuant to or under the laws of Georgia, located at 800 East 70th Street, Savannah, Georgia 31405. I am custodian of the records of said organization. That the within copies of records is an exact, full, true, and correct copy of the records pertaining to Christian Holm. I further swear that their said records were made and kept in the usual and regular course of business of said organization. It was in the regular course of business of said organization to make and to keep said records, and that said records were made at the time of such act, transactions, occurrences, or events therein referred to, or occurred, or arose, or were made within a reasonable time thereafter. This I swear and affirm on the 8th of December 2016. Appears to be a signature before me, the undersigned authority, a notary public in and for said county and state. In the state, personally appeared says Alexander Buchanan, who is known to me and who being, that appears to be.
Well, then we've got a problem
well,
with
that's the notary's name. The notary wrote their name in there. Is known to me and who being by my first duly sworn doth depose and state on oath that the statement of facts set forth in the above and foregoing petition are true and correct to the best of his or her knowledge, information, and belief, sworn to and subscribed before me on this, the 8th of December, and then Alexander Buchanan signed it.
But Alexander Buchanan is swearing to Alexander Buchanan, not Ampanash.
I believe Alexander Buchanan assumed that was where he needed to write his name.
Well, then we have a problem with a notary that doesn't know where to write their name. And so how can we assume that these are records kept in the ordinary course of business? Judge, again, it's December the 8th. The authorization was revoked on December the 6th. If they weren't admissible then, they're not admissible now.
And again, if the court, while they're not admissible on, I believe it's Exhibit 5, the same person, same signature, December 2nd, saying the same records are the records. Again, it wasn't a sworn statement, it is now a sworn statement. They are the records, Judge. And again, I understand that the Holms don't want them in because they don't want them to have what's heard. But again, they are proper, the department has done everything it can to get these records appropriately to the court. It is from someone, 500 miles away. And again, that they are. It was the intent of everyone on that was a sworn document. That continues to be what they were doing. It was a sworn statement.
Judge, intent doesn't equate to correctness. Okay, intent. The notary may have intended to put somebody else's name there. We'll never know that because that person's not going to be here to testify. The custodian of records doesn't say anything about reviewing the records that were sent. All she's saying is that she's going to say that the records she sent when they weren't admissible the first time are the business records. And who knows if that's true? That person's certainly not going to testify. So, like I say, I don't think if they're not admissible then, they're not admissible now. And especially since Mr. Holm revoked his authorization for any kind of release of information, whether it be HIPAA compliant or not, on December the 6th. That's made of record in the court.
And Judge, I think it would be different if it said Jonathan Schlenker down at the bottom of that instead of Alexander Buchanan. That is obviously a Scrivener's error. That it is obvious that the intent was to have that as a sworn statement.
Judge, I don't know that that's that obvious. You can't question that person. You can't question that notary. He's supposed to notarize saying, I saw this person sign this document. He didn't do that. He said he did it. So, who did it? He did it, or did Miss Ampanosh, or that's, I say still, the certification and the authentication of those medical records does not meet what's required by law, and especially after somebody has revoked any kind of information release that they might have signed.
But the release had already occurred. It was the certification. And again, there was no further documents that were released. That is exactly what she swore. Those are the records. Again, we talked with her on the phone. She said the only way I send them is by email, or excuse me, by fax, and I will send you a certification of the records. That is their policy. That is their procedure.
But Judge, we won't know that because that person's not going to be here to testify. So we won't know that. We have to, I guess, accept the state's word that it is what it is. And I don't know that we can accept the state's word that it is what it is because it's not what it appears to be.
Judge, and I would argue that I don't know that it's so much the state's word as the woman, excuse me, her name I can't recall at this moment in time,
Ampanosh,
who signed that affidavit saying that these are records kept in the ordinary course of business. My argument as to the notary would be that the notary was certifying her signature and provided that the oath and where the notary signed, provided that notary who is saying that she or he did, watch her sign that. A notary isn't merely saying that anything in there is true or untrue, just that that person swore that under oath.
And Your Honor, I don't disagree with Miss Miller, except for the fact that the notary didn't swear that she signed it. He put his name in it. So, for all we know, she could have taken this in there and said, here, notarize this. Is that proper? No. But we won't know that. Because we don't have the notary and we don't have Miss Ampanache, who certified these records, to testify to that.
And Judge, I would say Rule 903 goes on to say subscribing witness testimony is not necessary to authenticate a writing unless required by the laws of the jurisdiction whose laws govern the validity of the writing. So their presence is not necessary.
That's very true. Their presence is not necessary. We have a statute as far as medical records in Alabama for a reason. Go ahead.
I'm sorry.
Go ahead.
Well, Judge, if you notice, the state, the facts, date, and time on the records that the state is going to seek to introduce is the same facts, date, and time that's on the records they tried to admit last weekend. Same exact date. So they didn't get records refaxed over. All this is all they got, and I don't see any facts on this. So she bothered to take the time to put this in the mail. I'm saying she could have, we don't know. Well, I guess we do know that all the records that are in here are there. But I'll advise the court of this. We've seen instances where one person will go get a set of records, and then another person will go get a set of records, and there's additional pages or not as many pages. All they're doing is getting a certification, sworn statement after the HIPAA release or whatever release has been revoked to go along with the records that they had that weren't admissible last week.
And they weren't admissible because there was not a certificate of authenticity, and there is, or excuse me, a certificate of authenticity, and there is now. Again, it's the same records. I don't dispute the fact that they're the November 14th records that were produced. There was no reason to have the records resent because we had them. She had previously attempted to certify that those were the records, and then again, she now has sworn that those are the records. So these records are properly admissible.
Well, Judge, hold on just a minute. I further swear that said records were made and kept in the usual and regular course of business of said organization, and it was in the regular course of business of said organization to make and keep said records. Well, she doesn't say on here anywhere that the records that I sent the department on November the 14th, she can't swear to those. She's not swearing to the particular records that they have. This is a blanket authorization that did not come with any records that said that she'd been reviewed and were made in the ordinary course of business. She's swearing something that she hasn't done.
It was made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters, was kept in the course of regular conducted activity, and was made by the regularly conducted activity as a regular practice. She has satisfied all of those. It's wonderful that the council wants to add in extra things to statutes about what it must say, but again, it does not say there is nothing in the statute that says, I hereby certify that the records sent on November 14th hereby are the records. It is those three issues: was made, was kept, was regularly conducted activity. She has satisfied all of that. The affidavit is sufficient.
But it came with no records, Your Honor. It came with no records. So if it came with no records, then she's got to certify the records that were sent, that were inadmissible. Not just a...
Who's got the affidavit?
It's right there.
No,
Oh.
I think
think
it was,
Allison.
I'm sorry, I just wanted
that is all.
My overwhelming concern with it is this little, on the bottom, that says Alexander Buchanan personally appeared before himself. I have to take that document for what that document is. I can't go outside the four corners of that document. I can't infer intent. It is what it is. He says he appeared before himself, not Miss Ampanache appeared. I don't think that's enough to meet it. As far as that, I just think that's an error that's there, unfortunately, for the state, and very good for part of the parents. And I don't mean that ugly the way it sounded. It's a Scribner's error, it may be. I don't know. So with that, let's move on.
So the medical records from Savannah Counseling are deemed to be inadmissible. Is that correct?
Yes, however, remember, prior to you raising this issue, your client was under oath and took the fifth, and I can infer what I want to from his questions
Yes, ma'am.
and answers there too.
Yes, ma'am. I understand.
So, with that, it is now 1:42. Do we need to take a break?
I need a quick break, Judge.
Judge, we'll take a break and
Okay, go ahead. We're back on the record.
Judge, I know that you have ruled that you are not going to admit these records based on that for the purpose, I guess, of them being true. Is the court making any ruling as to far as if they're introduced for impeachment purposes of prior testimony?
Well, let's make that ruling when we get there.
Okay.
I think it's a little early to make that.
And I guess while we're asking, are we going to allow any testimony as to by an expert that would have examined those records?
Well, let's cross that bridge when we get there, because there may or may not be other issues that that person could testify about. I think saying at this point, yes, I'm going to exclude, or no, I'm not going to, is, I think the issue's immature at this point, not right.
Yeah. When do you want that, Justin?
All right, we're back on the record on JU 88.1. Just a matter of housekeeping before we get started. I have what was handed to me this morning, a report to the court for this phase of the proceedings. Do you have it?
Yes, ma'am, we did.
Okay, because I have not reviewed this yet. Ms. Miller, you have it?
I do, Your Honor.
Okay, and it was, of course, produced by the department. Big mouthful of words there. Haven't had enough coffee this afternoon. Okay, any other motion hearings that we need to address that we can think of?
Your Honor, in light of the court's last ruling, we would move to offer the records from Savannah Mental Health as impeachment. The court has taken judicial notice of the father's prior testimony. They contain inconsistent or we contend that it is inconsistent with his prior testimony, specifically him stating that he has only been diagnosed with, depression and ADHD, and I believe that the records indicate that it was something else. So at this time, we would offer them for the purposes of impeachment, not necessarily for the truth of the matter, sir.
Judge, the records are inadmissible, regardless. For any purposes, they're inadmissible in this matter. Not properly certified, authenticated. So we would object to any kind of attempt by the state to get the records in through impeachment. They're not admissible. And we would ask that the court direct this witness to that she cannot testify as to anything in those records.
Well, I don't know what she's going to testify to yet.
Well, I don't know what she's going to testify to yet, but if it has to do with anything that is in these records, that was covered in my motion in limine that if Ms. Couch is testifying as an expert, they can't testify as to inadmissible records.
Mr. Slinker?
Nothing further, Judge.
Okay, and you're asking me to admit these as far as impeachment to the prior statement Mr. Holm made during shelter care that judicial notice was taken,
Correct.
and not to the truth of the matter asserted.
Correct.
Is it your intention to utilize those records from that and any other testimony, anything like that?
Not at this time, Judge.
Based on that assertion, I think that it's appropriate to admit them as impeachment to Mr. Holm's prior testimony at shelter care. Again, I haven't read them. I think you've reviewed them somewhat.
Well, they're not certified.
And I understand that they are not certified. But as far as admitting into evidence, as far as evidentiary basis itself, they would not be a document that would be admitted in as far as a true and correct document. Is that
Correct, Judge.
correct? Okay. And
Yes, we would object to any testimony based on Mrs. Couch's having reviewed records that are inadmissible. Excuse me.
let me double check right quick with this. Just
Okay.
matter of housekeeping. I have not marked this.
And Judge, we would ask that you mark it as DHR's.
And since it was a very big contention, I really want to mark it, and that way we can identify what document we were speaking about when I said your authentication is not appropriate.
Is it 7, Judge? Would that be right?
I believe so. What I do with my list. Here's my list. Yes, 6 was not admitted, 5 was not admitted, 7
Yes, ma'am.
not admitted as the truth of the matter asserted, but is it understood for impeachment. Okay.
Just once again, we note on the record that we object to this, and the state is quite obviously wanting to get this in, I believe, for the truth of the matter asserted.
I'm listening.
The records are what they are. They're not admissible, and Ms. Couch can't testify to them, so you note that objection on the record.
I do note that objection. I will say this. At the time that Mr. Holm was on the stand and took the fifth to this, that objection was not pending. And to me, bringing these in for impeachment purposes, pretty much it's already been done. It's almost a moot issue at this point because that happened on the 5th.
Yes, ma'am.
Nonetheless, I don't know what testimony they're about to try to elicit from Ms. Couch, and we'll just go step by step. And I have to keep checking the recorder because it shows I have 1 bar of battery left. So if y'all, and I have batteries up here, but if y'all hear a little beep beep and see me stop, that's what's going on. Okay? The fallacy in technology. Ms. Couch, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Yes, sir.
Judge, is there any way to change batteries out before we start taking testimony?
We could. I just don't know how to do this test. Let's do that. All right, we are back on the record on JU 88.01 after changing batteries in our recorder. Ms. Couch, you have been sworn. Mr. Slinker, go ahead.
As a housekeeping matter, can I ask the defense to designate who's going to cross-examine?
Sure. That'd be Mr. Hall.
Mr. Holm will be cross-examining.
Yes, ma'am.
Okay.
We just decided that.
Please state
That's
your name.
fine.
Edith Couch,
And Ms. Couch, where are you employed?
with Couch Counseling.
And what do you do there?
I'm a licensed professional counselor.
And in order to be a licensed professional counselor, can you tell us about your education?
I had to get my Master's of Science in Community Agency Counseling through Jacksonville State University. I did 3,000 hours of practice under the supervision of another licensed professional counselor. I had to take the Licensed Professional Counseling Board test, which I passed. I have to stay current on my license, CEUs, and fees.
And can you tell us about your work experience?
I worked at Regional Medical Center Psychiatric Unit, which was a lockdown crisis unit. I also do private practice counseling with mental health patients. I do contract work with the Department of Human Resources, and I do contract work with the court systems.
So as a result, excuse me, do you have any special licenses besides your LPC?
I have national counseling accreditation. I'm a certified forensics addictions expert, and I'm a supervising licensed professional counselor.
And as a result of your training, are you able to do, are you able to provide counseling to people who suffer from mental illness?
I am.
And approximately, I know it's probably a long time, how many how many patients have you treated in your career?
I don't know that I could say. I work 40 clients a week, 5 days a week for the last 19 years.
Okay. So, that's a lot.
It's a lot. I couldn't.
As a result of your training and employment and licensing, are you able to make diagnostic impressions of people to establish a course of treatment for mental illness?
I am.
And have you completed diagnostic impressions throughout your career?
I have.
In order to complete a diagnostic impression, what, if any, instrument do you have to rely on?
In the past, it was the DSM-4, which you have to take while you're in school, and most recently they've changed it to the DSM-5, which I believe therapists are required to take as part of their CEU to update us on the changes.
So you've received training in the DSM-4 and the DSM-5?
Yes, sir.
Okay. And have you ever been declared an expert witness?
Yes, sir.
Approximately how many times?
To be honest with you, I don't know how many times. Usually it's stipulated to because I'm an expert witness lots of times in Cleveland, Gadsden, Calhoun County, but I don't know how many.
And you mentioned Cleveland, Calhoun,
Etowah.
Etowah. Any other counties that you've been qualified as an expert that you can think of?
Ranburne County. I believe those are the only ones that I work in right now.
Your Honor, at this time we would offer Ms. Couch as an expert in general counseling of people with mental illness, evaluating people with mental illness and coming up with an appropriate course of treatment for them, and in the application of DSM-4 and 5 to people with mental illness.
Yes, sir.
Okay. Could you tell me, are you a psychiatrist?
Judge, I'm going to object. I made a proffer of her as an expert.
And Mr. Holm obviously is not agreeing. I do believe Ms. Couch is an expert. However, I'm going to give a little latitude here to Mr. Holm, and I believe looks like he's got 3 or 4 questions written down there.
So you're going to allow him to void ire the witness?
To allow him to void ire the
Okay.
witness.
Sorry, Judge, I just want to be sure that I knew what we were doing.
Thank you. And void ire means you get to question.
Okay.
Okay, and it's just brief on the limited part at this point of, and Mr. Kirby, I'm sorry, maybe stepping on your toes as standby counsel. Just brief is to the limited part of qualification as Ms. Couch is an expert.
Sure.
Okay?
Okay.
I heard him ask you to ask me if I was the doctor.
Well, I was going to ask you if are you a psychiatrist?
No, I am not.
You're not. Can you prescribe the same medicines as a psychiatrist?
No, I do not.
Okay. Do you have a HIPAA release with my signature on it?
No, I do not.
Are you my doctor?
No, I am not.
Have you ever spoken to me in person?
No, I have not.
Have you ever diagnosed me in person?
I have not.
How can you attest to the view of any other doctor?
Judge, I object. she's not been offered to attest to the view of any other doctor. That's outside the scope of what she's being offered for.
Sustained.
Okay. I don't know any other questions. That's all that I need to show that she's not my doctor. Okay. Because she has stated that she's not a psychiatrist, we would like to object to qualifications of an expert witness.
Mr. Slinker, any response to that?
Judge, a LPC licensed counselor has the credentials and is allowed to, under the laws and provisions of the state of Alabama, to make diagnoses of mental illness. And that has been satisfied, and that is what she's being offered for.
So noted, and we will qualify Ms. Couch as an expert at this time.
Now, Mr. Holm asked you this, but you've never seen Christian Holm or Danielle Holm, the parents, correct?
No, sir.
Okay. And can you tell us what schizophrenia is?
Schizophrenia is a brain disorder. It's in the DSM-4 and the DSM-5, and it has certain criteria that has to be met. You have positive symptoms and negative symptoms of schizophrenia, and it affects a person's thoughts, moods, and behaviors.
Is this something that's, is it biological or is it mental? What is the cause of schizophrenia?
According to the diagnostic criteria, schizophrenia is actually a brain disorder, not a mood disorder. They believe that it is caused in part by genetics, perhaps some environmental factors, chemical imbalance. At one time they used to think that schizophrenia was purely genetic and that it could not be substance induced, and now they're finding that there is perhaps some genetic tendency, but you can also now have a substance-induced schizophrenia.
And I know you hit on some of the traits. What are some of the hallmark traits of someone who suffers from schizophrenia?
I believe the most prominent ones are the positive symptoms of schizophrenia, which are your delusions, hallucinations, disorganized speech. Some of the ones that are less prominent or less in therapy would be your negative symptoms, and that would be inappropriate or incongruent mood and affects, anhedonia, energy.
What is anhedonia, energy?
I'm sorry. I'll use anhedonia is a lack of pleasure and what one used to enjoy.
Okay. What else?
There's energy, which means that you have fatigue. Some of the negative symptoms are inability to focus, almost like an ADD symptom. There's some speech problems. Sometimes there are some behavior problems. One of the main behavior problems that people might know is catatonia, where you actually don't move your body. There could be some agitation where you're okay one minute, you stand up, you sit down, you stand up, you sit down, you may go from agitated to calm. So those are some of the negative symptoms associated with it.
Now, if someone has schizophrenia, are they going to exhibit all of those or just some of those?
Some of those.
Okay. And what are the underlying criteria for a diagnosis of schizophrenia?
Okay, you must exhibit one of the three positive symptoms: delusions, hallucinations, or the disorganized speech. And it must be for a period of more than 1 month. Then you've got to show one of the negative symptoms.
And specifically when it comes to children, what are the concerns, if any, that would be present of someone with schizophrenia who was responsible for the care and custody of a child?
That would depend on the schizophrenia. For instance, if you're paranoid schizophrenic, one of the concerns is that if someone becomes a part of your delusion, your psychosis, and if you become paranoid or afraid that they're a harm to you, then a paranoid schizophrenic may strike out first. It would depend on what their delusions are at the time, if they're seeing things, hearing things, and their ability to distinguish between what's real and what isn't, and whether or not that person would be involved. And that,
Would it be concerning for someone who was schizophrenic to not be on medicine and have custody of a child?
yes.
Okay, can you tell us, would it be for the same reasons we just went through?
Schizophrenics need family support. They need someone that can help them know when their thinking is not correct, to reach out for help when they need it, so it takes family support. They need the medications to help with the positive symptoms, such as psychosis, delusions, hallucinations. They need those medications to help them diminish the positive symptoms. And then some of the medications also help with the behavior, but mostly with the behavior it is cognitive behavior therapy, because they need to learn what's not real, what isn't. Family, psychotropic medications, and counseling. Even though they don't prevent relapse of the symptoms, they do help a patient become more aware.
In your expert opinion, would that be assumed, or would you believe that to be absolutely necessary for someone who is schizophrenic to have custody of their child to be actively engaged in a pharmacological regimen as well as a cognitive therapy regimen?
Yes, sir.
And are you also familiar with delusional disorder?
I am.
What is delusional disorder?
Delusional disorder is more of a non-bizarre thought process. There is some truth, perhaps, in their delusion. They are able to function more effectively than someone with psychosis. And the difference between the delusion and the psychosis is that delusion is an entire break from reality, whereas delusion is inappropriate beliefs that are not based on the way the person was born or the culture that they were raised in.
Consistent with someone who had delusional disorder, would that be someone who submitted a 34-page demand letter asking for $1 billion?
I'm going to object.
Judge, I object
No, I'm
to.
sorry.
I object to him.
Objection, that's speculation, is it not?
Your question was?
My question was, consistent with delusional disorder, would be someone submitting a 34-page demand letter asking for $1 billion?
Are you asking that as a hypothetical?
Yes, ma'am. I can say hypothetical.
I mean, if you're asking that as a hypothetical, she can answer it.
Okay, so
Hypothetically, if someone were to submit a demand letter, approximately 34 pages in length, asking for $1 billion.
Objection, Your Honor. She doesn't even know why.
Okay.
Yeah.
Let him finish his question, okay? Let me hear all the question, and then we'll get to your objection.
Would that be consistent with someone who is suffering from delusional disorder?
well, that's possible. I don't know that I haven't read the letter to see as to the content, but that's possible.
Would signing a document in blood be consistent with a delusional disorder?
That's possible, yes.
As part of the DSM-4's excuse me, Judge.
I brought mine too.
Okay. I was looking for my highlighted section.
Oh, okay.
As part of the DSM-4's statements of what might be someone with
You
delusional
have
dis...
a copy of what you want.
Oh,
to-
yes, ma'am.
Then I can know exactly what you're referring to.
Hey,
Right on my page. Okay, you're under delusional disorder.
yes, ma'am. If you just give me 1 second, let me give... Oh, yeah. Sorry. All right, ma'am. Specifically as part of the DSM-4's list of what would be some of the criteria for delusional disorder on page 326, there is a... No, I have missed it here. Thank you.
Are you under specific culture and gender features?
No, ma'am, right above that.
Okay. Associated features and disorders?
It would be the line starting with especially with their persecutory and jealous type.
Yeah, okay. The specifier subtype.
Yes, ma'am.
Okay.
Can you read what the DSM-4 says with regards to that line and perhaps the next line?
The persecutory type?
Yes, ma'am.
Okay. Subtype applies when the central theme of the delusion involves the person's belief that he or she is being conspired against, cheated, spied on, followed, poisoned, or drugged, maliciously maligned, harassed, or obstructed in the pursuit of long-term goals. Small slights may be exaggerated and become the focus of a delusional system. The focus of the delusion is often on some injustice that must be remedied by legal action, querulous paranoia. And the affected person may engage in repeated attempts to obtain satisfaction by appeal to the courts and other government agencies. Individuals with persecutory delusions are often resentful and angry and may resort to violence against those that they believe are hurting them.
Would that be of a concern to you, someone with a delusional disorder who was under, well, first off, someone who had a delusional disorder, would that be of concern to you having custody of a child?
Yes,
And why is that?
because of the persecution, they always feel a slight. They always feel that someone is against them, and they will resort to either violence, legal actions, or other actions in order to have their needs met.
And could that put a child in immediate danger?
If it's part of the delusion, yes.
If someone was suffering from this type that you just read about, would that cause you concern?
Yes,
Okay, and would it be for the same reasons?
yes, sir.
Now, what would be the course of treatment for someone who was suffering from delusional disorder?
The same treatment as with schizophrenia. Psychopharmacology and counseling, because delusional disorder, even though given its own diagnosis in the DSM-4, under the DSM-5 has been moved to the schizophrenia spectrum.
So delusional is a offshoot of schizophrenia itself.
Yes. It's one of the diagnostic criteria under positive symptoms.
Okay. Now, you mentioned earlier that also family support would be important to you.
It's important.
Can you tell us what you would be looking for in
With-
family support?
With family support, schizophrenia is a difficult disease, and oftentimes the person with schizophrenia or delusional disorders, they do not think that they have any problems. So they're less likely to seek treatment, they're less likely to take medication. They have some cognitive issues that are distorted, and they're not very responsive to therapy because they don't believe that their delusion or their distorted thoughts are false. And so it takes family to be able to help them understand the deficits. They need support because a lot of times they don't find support within the community. And it helps with someone else is there to safeguard against relapse. They may see behaviors and symptoms and be able to get them to the doctor and get them to the therapist before they start that cycle.
Would it be a concern to you if that family support was actually participating or going along with the delusions?
You mean as in a shared delusion or shared psychosis?
Can you tell the court what that is?
A shared psychosis or a shared delusion is where there's another person who may have what we refer to as a passive temporal delusion disorder, or the ability to have delusions, and it takes someone in active delusion to bring that out. So they already have an issue. And so what that is that the person who has the delusion that's active, then the passive person's job is to help them reach their goal or carry out their goals of their delusion.
What would be your concerns if you had two parents and one was suffering from schizophrenia or something on the scale, and someone who was also then suffering from shared psychoses?
They both have to participate in counseling. They both have to participate in psychopharmacology. When I'm talking about family support, what I'm talking about are the family members that have a healthy cognitive outlook. Those are the ones who would be the support, not the ones who would fall in with the delusion.
Just if I have 1 second.
While you're taking a second, Mr. Cody, do you need a second?
I do.
Okay, we're back on the record. J8801, Ms. Couch, you remain under oath. Mr. Holm, it's your chance to cross-examine Ms. Couch if you so desire.
Judge, did I rest? Sorry.
Oh,
My understanding was you had finished questioning and Mr. Holm was about to...
I'm sorry, Judge.
I was checking the
I was
Okay.
checking with them.
All right, okay.
Make sure I
Sorry.
hadn't missed anything, and of course I had. Someone who is schizophrenic, is it common that they comply with their regimen of treatment?
No.
What is the normal prognosis? Well, strike that. How do people normally react who are treated with, who are diagnosed with schizophrenia and then are undergoing treatment?
Okay, could you repeat that?
Sure. In people who are undergoing treatment, how does that normally progress through their lifetime?
They exhibit symptoms. I believe less critical diagnosis is given until they meet certain criteria for schizophrenia. They participate in counseling, they participate in psychopharmacology, and it's a constant in their life because there's relapse proneness with it. And a lot of time with the medications, the side effects of the medications, the distorted thinking, there is a tendency to pull away from counseling, or when your medication starts to make you feel better, you think that you're okay, so you quit taking your medications. and then the cycle begins again. But schizophrenia is treated, not cured.
Is it common that someone who is under treatment will then suddenly stop taking all their medicine?
It's common.
Is it common that they will be doing well and then suddenly, again, make that turn and stop?
Yes. From what I've experienced.
I don't think I have any questions, Judge.
Yeah, Mr. Holm, I'm sorry.
Hey, sorry.
It's okay.
Okay, is anything in life possible?
Yes.
Okay.
Within reason.
Within reason, right, okay. So, now, possibility is not fact, right?
No. That's right.
And if one has different views of religion, that's not schizophrenia, right?
No. Not per se, no.
Okay. So if one chooses to live a certain way of life, that's not schizophrenia.
Not in and of itself, no.
All right. So let's say that if someone wanted to live in a more natural state or natural way of life, that's not schizophrenia, right?
No, not put like that, no.
Okay. All right. Can schizophrenia be cured?
No.
Are you born with it?
They believe that there is a genetic factor. So you are born with the tendency, like diabetes, you are born with it.
Okay. Could you tell me why a doctor would prescribe medicines for one diagnosis, then give another diagnosis, then go back to the diagnosis before?
Why would a doctor do that?
Yes. Let's say...
Just won't ejaculate. Ejaculate. I'm gonna. Wow.
Ejaculate?
Yeah. If I clarify that on the record.
Please do.
Do we need to leave the room?
I would like to, can I leave?
I would like to object that's speculation as to why a doctor would do one thing and then another. She's not been, I mean, that calls for the mental operation of another.
The way it was phrased, yes, it does, sustained.
Okay. Well, really, Your Honor, I completely agree with everything she's saying. We don't have any other questions.
Okay. Anything from the guardian?
No, Your Honor.
Any redirect from the state?
Can religion become an issue, though, with someone who is schizophrenic?
It can be. There's a fine line between religious, freedom of religious pursuit and then what we refer to as religiosity.
And can you tell us what religiosity is?
That is not my field of expertise. It is a symptom of schizophrenia, such as grandiose. The religiosity would cross the line. But I don't know that I don't know how to explain that to you.
Okay.
I'm sorry. But yes, religiosity is an issue.
Would someone having visions be a symptom of schizophrenia?
Yes, hallucinations, that's a positive symptom.
The belief of the Freemasons persecuting you or causing your ID to disappear, hypothetically, would that be...
Objection, Your Honor, leading the witness.
hypothetically,
Go ahead.
They're offering as truth.
I believe you did say hypothetically.
Hypothetically.
But just in case you didn't, why don't we start over with that
Yes, ma'am.
question and rephrase?
hypothetically, if
And-
someone...
And break it down, okay?
Yes, ma'am. I apologize if I'm going too quick.
You are talking a little
We're
fast.
talking fast,
Yes.
I'm trying to keep up.
I generally warn everyone I talk fast normally, and I talk fast.
You are
sometimes.
in the South,
I
boy.
know. Well, I didn't grow up here. No one could understand. All right, so hypothetically, if someone claims that the Freemasons were persecuting them, would that be a symptom of schizophrenia?
Under persecution?
Yes, ma'am.
Yes.
If, hypothetically, if a parent believed that their child was a prophet, would that be a symptom of schizophrenia?
Yes, that would go on with religiosity.
If, hypothetically, if a parent believed that a child was somehow divine, would that be a symptom of schizophrenia?
Under religiosity. Delusional disorder.
Another question.
Would you have the
Holm?
same,
Go
yes,
ahead.
sorry. Would you have the same answers if Joseph and Mary would ask you the same questions?
If Joseph and Mary were to ask me the same
Yes,
questions?
if they were here present today, would you answer yes?
Yes,
You would answer the same way.
I suppose so.
So so you would say that Joseph and Mary had schizophrenia.
Based on the knowledge of this culture,
Mhm.
of this society, and the historical evidence, if a Mary and Joseph type person were to present themselves today, then yes,
Do you believe in Jesus?
yes,
Okay. But you don't believe in Joseph and Mary.
I do.
You do believe in Joseph and
I
Mary.
do believe in Joseph and Mary.
Okay. Can people have different beliefs?
They can.
Does that mean that they're schizophrenic?
No.
We have no other further questions. No other questions?
Guardian?
Just a couple. Ms. Capps, you testified that people who have the diagnosis of schizophrenia are relapse prone. Is that correct?
Yes, ma'am.
Generally, how often does relapse happen? And if it does, is there a certain period of time before that occurs? Is it immediate? Can you, I guess, shed some light on that?
With schizophrenia, it depends on the person, on the age of onset. Schizophrenia generally hits in the prime of your life, which makes it the more devastating. But every time you have, if you're non-medicated and you have a psychotic episode, they believe that, or what I've been educated on and taught in the hospital was that has some residual effect on the brain. And so that diminishes the ability to overcome the next psychotic break. And that's why the medications to keep those psychotic breaks from happening and increasing the chemical imbalance in the brain. Relapse proneness depends on the stress. Schizophrenics don't like a lot of external stimuli, a lot of social interactions. So there's some things that would set them off, so to say. So with each person it's different. And their ability to pull themselves back into reality is different. So there's really not a pat answer, but I mean it is. There's no there's no cure for it.
Hypothetically speaking, if someone had a diagnosis of schizophrenia, removed themselves from their medication, would you feel comfortable with them caring for an infant?
Objection. Your Honor, ask and answer.
Sustained.
I think that's all I have, Judge.
Anything further from the
Nothing further from the state, Judge.
Okay. That should be released.
Please, Judge.
Okay. Go to the next witness. Or do we need to take a break? You good? Yes, you're good.
Judge, we can take 5. Before we take 5.
We'd offer that the records weren't necessarily used for impeachment purposes, so that they be deemed inadmissible again.
I'm lost as we have been over the records before. The records were not used at all in that testimony. I'm confused as to why we're going back over.
Right, but I think you admitted them for impeachment purposes, and we're asking that they be excluded completely again and not used for any further testimony.
Judge, I'm going to object. This has been raised. The court has ruled. It has been raised. The court has ruled. Judge, we would ask that. If counsel wants to note it for the record, fine. But then, again, I think it's
Objection, leading the judge.
No. The state didn't necessarily didn't use the records for impeachment, so I think they need to go back to the same status that they were.
I've already ruled on that. We didn't allow Ms. Couch to utilize those records.
Okay.
I think at this juncture, in relation to Ms. Couch, your objection's due to be overruled.
Okay.
And I'm assuming that's where you're going to this particular witness with these records to make sure we aren't using them in that conjunction, correct? Or am I misconstruing?
No, I'm talking about future testimony. They were deemed inadmissible prior to Mr. Schlinker's correct motion, I guess, to bring them in as admissible for impeachment purposes, but they were not used for impeachment purposes. So,
Judge, I offered them for the impeachment purposes of the testimony that the court had previously taken judicial knowledge of with regards to the parents' testimony at the shelter care.
And in addition, those were the same records that were utilized
But it
when
was not-
Mr. Holm was on the stand.
Correct.
And that was the limited scope. I
Correct.
said those were admissible for impeachment. Very
Right.
limited.
Right, and that was all they've been used for.
It was acknowledged, but not with those
Judge, I will
records.
Oh.
object. One of them gets to argue, Judge.
That's correct, Mr. Kirby. That's your motion to argue. Again, we're going over semantics or at the same thing. It was on that very limited.
Okay.
Not carte blanche that you can come in here later on and say very limited. Mr. Holm testified at shelter care. This is what he said. Mr. Holm testified at the adjudication phase the last time we were here. This is what he said. For impeachment purposes, here's what the records say, not for the truth of the matter asserted.
Correct.
Very limited.
okay, but if the records were used in the shelter care hearing,
They were not used in the shelter care.
okay.
I keep forgetting you weren't here.
Okay.
I'm sorry.
Yeah.